right. Peace, peace, everyone. Welcome to the Moorish Investigative and Research Committee. This is Saturday, August 24th, 2024, 3 p.m. Eastern Standard Time, session 4. Welcome, everyone. Keng El Bey is the chair of the committee. Yours truly, Abdullah Ilte Mosi Bey, is the committee advisor, Shimalakai Bey, committee advisor, Amanda Siegel, committee secretary, Akono Sankofa Bey, committee co-secretary. The sponsors are the United Tribe of United. Go back up, sponsors. Go back up to sponsors.
Slow down, Abdullah. Your sound is a little messed up.
I'm sorry. Let's go back up. Sponsors: United Tribe of Sovereign Moors and the Rockin' Post School of Government and International Law. So we have that one. Everybody see that there. All right. Go up to today's topic. Title is A Lesson in Jurisprudence, Philosophy of Law, and Legal Principles as the Foundation to Run Government and to Handle Legal Cases. Once again, a lesson in jurisprudence, philosophy of law, and legal principles as the foundation to run government and to handle legal cases. Preparing the Moors, conscious and unconscious, Black, Negro, colored, and African American for self-determination, self-governance by teaching legal principles and jurisprudence, philosophy of law, and legal theory. Restoring the Moors' fundamental rights, personal rights, through rebuilding Moorish government. Moorish Intergovernment Alliance and Central Moorish Imperial Parliament Council, restoring Moorish national political unity through education. Restoring the Moors' fundamental rights, personal rights, through rebuilding Moorish government and restoring the knowledge of Moorish nationality, Moorish history, Moorish culture, jurisprudence, philosophy of law, and legal principles among the Moors. The May 18, 2024 Moorish Political Unity Conference is a political mechanism of restoring the domestic and international politics to protect and secure the common good of our people, both conscious and unconscious Moors, and to serve as the caretaker and voice for them among the family of nations in a provisional temporary capacity, adhering to the principles of self-determination, political legitimacy, the will of the people, and the consent of the people. Fundamental rights is a legal principle. The purpose of Shimalakai Bey's proposal of the establishment of a Moorish Imperial Parliament Council through the union of various Moorish body politics is to restore the protection measures of our people, the Moors, conscious and unconscious, fundamental rights through the following: the protection of our Moorish nationality through international relations, the protection of our Moorish nationality through Moorish government structure, the protection of our Moorish nationality through Moorish treaty enforcement and Moorish consular relations, the protection of our Moorish nationality through our Moorish diplomatic protections, the protection of our Moorish nationality through Moorish consular protections, the protection of our Moorish nationality through Moorish diplomatic channels and central authority, the protection of our Moorish nationality through Moorish consular relations and central consular notification. Let me read that again. The protection of our Moorish nationality through Moorish consular relations and consular notification. The protection of our Moorish nationality through Moorish consular relations and Moorish consular courts. There's two elements in the political meaning of nationality, and that's allegiance and protection. The people give the allegiance, in return, government gives protection. That's the political application of nationality. the Europeans have removed the protection of our fundamental rights by dismantling our Moorish government through Spanish, French, Dutch, English/Great Britain, Portuguese, conquest and colonization, wars over the period of centuries. The Moroccan Empire is in a state of temporary collapse, dismantlement. I used this analogy. Our mother is in the hospital. That is still our mother, though. That is still our mother. She's been in the hospital for over 200 years. She's been in a state of a coma for over 200 years. That means a coma is a prolonged state of unconsciousness. And let me give you the international law language. That is known in international law as the loss of sovereignty, a temporary extinguishment, disintegration, dismemberment of a state. To reverse that, so that is under the law of war. To reverse that, we go to the law of peace. We look to the law of peace and international law. We have reversion to sovereignty, recovery of lost sovereignty, restoration of statehood. So this is important to, so this is where we're on the road. We have not recovered. What does it look like, Abdullah, to recover our lost Moorish sovereignty? You wouldn't be talking about United States anymore. I mean, if I hear somebody say United States, then if I hear somebody say North Carolina, South Carolina, Michigan, if I hear them, then you ain't recovered because they won't exist anymore. I'm just keeping it real. Just keeping it real. We're talking about the recovery of lost sovereignty. The recovery of lost sovereignty is the end of European colonization. I mean, all right, this follow me. I come to your house. I take over your house. I hold you in captivity in your house for 10 years. And I say, and you say you recovered the sovereignty, yet I'm still in your house. I'm still in your house. How you recover what? I'm still in your house dictating to you in your house. You got to kick me out the house. I got to leave the house. Somehow, some way, I got to leave the house. And you now have control. You're now negotiating treaties with China and France, and you having trade with China, and you have embassies and consulates in China and England and France and Burkina Faso and so forth. You know what I mean? You're doing trade and commerce, and you have your monetary system and your Moorish passport. That's what it looks like. That's what it looks like. We have to know what it looks like because we're not there. I mean, it's all right for us not to be there, but it's not all right it's all right for us not to be there right now, but it's not all right for us to make a claim that we're there and we're not there. It's not all right for us to make a claim that we're there and we're not there. It's all right for us not to be there and be on the road to recovery of lost sovereignty. It's all right for that. So to make a claim that you're there, because I've heard for 30 and a half years, I've heard various groups in 30 and a half years make a claim that they're there. I mean, that they have recovered their lost Moorish sovereignty. So we just gotta keep it 100. Gotta keep it 100. You put that up, back it up, Terrence. You got to keep in mind, I've taught misconceptions for 25 years. I'm going to keep it 100. I taught misconceptions for 25 years, for age 25 to age 50, to thousands of people. I will not teach misconceptions. I don't care who it is. Jurisprudence. Philosophy of Law. This is written by Ruth Brooks, July 19, and the resources July 19, 2022. What is, can I have a reader? We have a reader. Other than Amanda. Have a reader
All right,
other
here
than
we go.
someone named Amanda. A reader other than someone named Amanda Siegel.
All right. Jurisprudence is the philosophy of law. Includes the study and analysis of law generally, as well as its systems, institutions, and principles. Legal theory, meanwhile, focuses specifically on the law in practice, how it functions and operates within societies. So while jurisprudence and legal theory are intrinsically linked and often used simultaneously, one, legal theory is actually a subset of the other, jurisprudence.
All right. King. We're gonna just let's go back down, Terrence. King.
Yes, sir.
I want to give give some explanation.
Okay. When we start talking about the philosophy and the theories that's associated with these two, we need to understand that what has happened over time is that they have took our understanding of law, right? Men came together to shape and form this. So when we understand how the theories, okay, give me 1 second. So when we understand the legal theories and legal philosophies, the philosophy works hand in hand. I apologize, my daughter is but we get a better understanding of how the philosophies and my mind just went blank and work. So I got kind of thrown off. So
How it works hand in hand, you mentioned?
yeah, they work hand in hand. So the philosophies of it deals with how everything was done through observation. Oh, sorry.
So you ready, King? All right. So we're looking at the concept of jurisprudence. You have jurisprudence is the philosophy of law, which is you have what is taught in law school, and most people are the general publics do not know jurists. They don't know those. There's very few people who come across those who know philosophy of law. Of course, they know, you see lawyers every day, you know what I mean? You have some of your kinfolks. You see lawyers all the time, but they're not taught the philosophy of law in law school. The philosophy of law is not taught in law school. So we'll make it very clear that, all right, you can teach attorneys this today. They're not, because they're attorneys / lawyers, because they use both interchangeably. That doesn't mean they have a knowledge of the philosophy of law. We're talking about the foundation of law. And therefore, it gives one a better insight on, because you're dealing with the essence of law, dealing with how law has been established. So you have also a solid foundation on legal principles. So let me know when you're ready, King. Just let me know when you're ready.
I'm ready.
All right.
I apologize for this disruption. So when we talk about the philosophy and understand and the legal theories, okay, the philosophies has helped develop the legal system and help understand what we're doing with the principles, right? Then you have the theories that work hand in hand that help shape society by understanding how we need to look at things and how they need to inner working. So you got the philosophy and then you got the theories. So we talking about
Hey, King, put your face into the camera.
my
You got
face. My face ain't on the camera.
half your face it is. Half your face. All right,
Okay.
we good. Right there. Right there. All right, good.
Okay, so you got to think about, like the scientific things, and we break it down theories. So they go through application. The philosophy is the understanding, and the theory is the application in which it's used to help solve social norms. So this is shaped over time, and equity was the element that then developed these theories and philosophies. So this was done through observation. Man had understood himself to shape these applications so that he can better govern oneself and know how to act and treat himself well as treat others. So this shaped codes of conduct. This shaped not just codes of conduct, it's shaped the whole legal system based on the philosophy and these theories. So one is done through observation and one is done through application so that we can better see and shape our society. So when we're talking about a form of government, we need to understand, so you got cultural, right, norms and system norms. Hold on.
We're talking about foundation, the foundation of law. We're talking about how societies are shaped. And you begin that you'll see that when we get into the article, we read this before, and I put this out maybe 3 years ago. I shared this article 3 years ago for the first time. The history of the nature of equity jurisprudence. We're going to read an excerpt. I did type an excerpt, page and a half or 2 pages of that article. The history of equity jurisprudence. You begin to see that these concepts began with us. All right, you ready, King?
Yes, sir. I apologize. I'm just trying to keep the back going. So one is based on observation and the other one is based on application.
Wait, put your entire face in the camera. Just move there. All right, good.
So one is based in observation and one is based in application. So once you understand, okay, once we learned how to govern oneself, we then set a stage of how we wanted to be represented and to deal with other societies. Through this concept, we was able to evolve and expedite the world in civilized manners and customs and codes and practice and ideas and understanding, and which brought about this wisdom of this legal system. Without understanding how this stuff is developed, to really understand, for us to sit down and use inductive and deductive reasoning, this is the process through these applications, through this philosophy, and through these theories. This is where the inductive and deductive reasoning had developed. Through this observation, through these practical norms, through observation of everything from the planets, the stars, we learn how things behave, and we've been able to identify with these things and then put things into a set of conditions, to a set of social norms in which now we can measure. Without these principles, these legal principles, without these applications of law, without the source of law, without all operations of law, these came through observations, and that they developed this system based on these this theory and philosophy. And now it birthed what we call now these legal systems, these political systems. And it allowed us to move about and act and act in a conduct that was better for everyone, to allow people to thrive. Without this social construct, without this cultural construct, we would not see civilization today as it is. We developed these systems. The Europeans have adopted our philosophies and took this knowledge and used it against us. This is why they pollute our airways. This is with rap music that's harsh. This is why they pollute our food, because they know that the food help also determines behavior and everything. They corrupt everything from agriculture to everything. Why? Because they know that this knowledge is our salvation. And without understanding how this works, that developed these principles in these legal systems that created the politics and the legal structure in which now we see today, we would be back in the situation where if we learned this, this would allow us to rise back up and take the seat, take our rightful seat as heirs to these treaties. So it's very important that y'all pay attention to this. Understand how jurisprudence to be able to allow you to critical think. And the theory based on these applications so that we can better acquaint ourselves with everything that we're trying to do. Because what I see today is the misconceptions that come out of ignorance. That come out of somebody let me tell you where the birth of the misconceptions came from. People were getting injured and they wanted remedy. And then out of that, people were crying out. So Moorish was out here trying to find a solution. But through that solution, through that evolution, through that process, people started being able to what? Use people, take advantage of people. It was financially lucrative because where there's smoke, there's fire. Where there's problems, there's money. And this is why they create what they call, what is it called? Problem, reaction, solution. Problem, reaction, solution. They create the problem, they make us react, and they got the solution. That is lucrative to the European business. So they do this, they create this hysteria based on the things that they understand using our own knowledge. Took our knowledge and created a weapon today that what we see is colonization. Without us rising up to learn these things, and I'm saying this, we can't be haphazard without learning these things. Or we're gonna go back to the same condition, looking for people to give us remedy, and they're going to give us this pseudo law and has no real remedy because it's not rooted in these principles. It's not rooted in true understanding of jurisprudence and the legal theories to allow us to be able to thrive. They know that the knowledge is the answer. It's not the dollar bill. It's not. And a lot of those who read the Constitution, they should know this because there's no word bank in the Constitution nowhere. If you are a true constitutionalist, use and understand jurisprudence and the theories, you would know based upon the formula, the application in the formula, because there is a formula in which you should be able to use to measure, to be able to understand if this is accurate or not. This was what me and Abdullah is trying to do. I have been so enriched. I am thankful for his presence because he allowed me to even elevate even higher. He's seen the knowledge that I have, but I didn't understand the knowledge that he possessed and how grammar and all of this worked. Through the knowledge that he has, I don't want to be long-winded on this, but you guys, y'all have to understand these
The
principles.
most important, brother, flow, bro, is important because this is foundational. Go ahead, brother. You to say what you got to say. This is foundational.
So, based upon these philosophies and the theories, right? We talking about observation and application now. We talking about observation. This is how science works. You take an observation and then you theorize about based on certain things. It's rooted in elements. We expose certain things to certain environments, and then we see how they react and how they change and interact with new stimuli. So when we understand this, we can better set out the groundwork, because without knowing this, you can't run a government. I promise you, you can't. I promise you, if you don't sit down and get this through, you won't run a government. You will never reach remedy. And you won't get remedy on a domestic level without understanding this. This is why I'm breaking it down. I see so many Moors through me and Benelay. We used to help so many people. Once I gained this knowledge, I understood certain things. And I was able to help people from all over because I understood how these things work together. So I just want you guys, I'm thankful, and it's time for us to get back in position. Me and Abdullah been working on this all morning for the last couple of days, and we got more and more information to present to you guys, to give you guys all the stuff necessary to help develop and grow. I yield, Abdullah.
Right. That was much needed, but this is foundational. Foundational takes time. That's why I let you flow, King, because the foundation is key. The reason why I said the King, that I'm picking up stuff because I understand principles of I said, King, we're gonna use analogies. All right. If you are a carpenter, let's say, or I use the auto mechanic. An auto mechanic, when they do what's called troubleshooting, that is a thought process. The troubleshooting. All right, they're troubleshooting. They're using what? Inductive reasoning. Inductive reasoning to troubleshoot, because you're looking for, different part. Here, it's not that. It's not that. It's not here. All right, and then from troubleshooting, you draw a conclusion. So that is called inductive reasoning. Deductive reasoning is when using what you have the principle, and you're looking for situations. All right, this principle is applied to this situation. But inductive reasoning, you don't have the principle. You're looking at situations and what's these situations, and you draw a conclusion. All right, just the finding of facts. The finding of facts, that is inductive reasoning. So I don't want to get off the topic there, but so when you're looking at, so I wanted King to spend time because it's foundational, and that is what's needed. So as you notice that I put what Shem has, Shem's proposal and restoring fundamental rights to the Moors. Fundamental right is a legal principle. So what we're doing is preparing Moors to run government and teaching them legal principles. Each legal systems have legal principles. So we'll continue because I'll get back to that as we go on. All right, we continue, Terrence. And so we have another reader. What is the purpose of jurisprudence and legal theory? Can I have a reader?
Well, I'll read. Jurisprudence and the legal theories help people to better comprehend the law, the legal system, and the legal reason. The study of law include its origin, history, and its principles. And the legal philosophy provides a deeper understanding of the subject. It also helps illustrate how the law has been shaped.
Stop there, King. Provides a deeper, all right, doesn't read understanding. It has deeper, provides a deeper understanding. So you have comparative, you have positive, deep, comparative, deeper, superlative, deepest. All right, so this is the comparative, all right, deeper. What type of understanding? Deeper understanding. So why is the word deeper there? It's a deeper understanding of the subject. I just want us to, because this is how I read. This is how I read. So I got to give people insight to how I read. This is what Terrence wants me to do. Terrence wants me to do this, of giving people insight into how I read. I stop there like that. Deeper understanding. All right, continue, King.
Okay. It also helped illustrate how the law has shaped and been shaped by societies past and present. This is because a thorough understanding of legal philosophy and legal theory.
King, we got thorough. Doesn't just read understanding. Doesn't read this is because a understanding, a thorough. So we have deeper understanding and we have thorough understanding. Continue, King. King?
This is because a thorough understanding of the legal philosophy and the laws theoretically and historically foundation assumes that those working within the legal systems better understand the fundamentals of the law. It enables legal professionals to appropriately apply the law and better perform legal tasks and activities.
Now you read here, it says fundamental law, go back there, Terrence, a better understand the fundamentals. So it doesn't read better understanding the law. Better understand the fundamentals of law. So you have the fundamentals of law. All right, so if you were to give this to an attorney to read, is this something that they had in law school?
No.
What we're doing right now? Is this what we've done over the past 20 minutes? Is this a lesson that was given to them in law school, in some class in law school that they had in 3 years?
No.
Do they talk about, is there somewhere in their textbook, in the 3 years they have in law school, where it reads fundamentals, understand the fundamentals of law, or it just says to understand law? What is it read in this textbook? To understand law, or does it read the fundamentals of law? Does it read in their textbooks in law schools, the attorneys and lawyers, provides a deeper understanding? So I got to point these out. So you'll be teaching attorneys / lawyers. I could continue.
The
You have a
five,
reader? Mm-hmm.
the 5 schools of thought in general jurisprudence. Philosophical school of thought, analytical school of thought, historical school of thought, realist school of thought, sociological school of thought, common legal theories, natural law, learned positivism, legal realism.
That's supposed to be legal positivism. Legal. That's the
legal positivism. Yeah. Okay, legal positivism, legal realism, critical legal studies, types of jurisprudence, historical jurisprudence, general jurisprudence, social, is that social or special jurisprudence?
Special.
Special jurisprudence, analytical jurisprudence, positive jurisprudence, normative.
Yeah, jurisprudence. And this article is on the Telegram page, the Moorish Investigative Research Committee Telegram page. This article. Okay. That came from an article. All right, continue. We have another reader. You have another reader.
Legal principle defined. Legal principles, legal values, and legal norms. Are they the same or different? Academicus, International Scientific Journal. Legal principle or legal notion. A fundamental truth, a comprehensive law or doctrine from which others are derived or on which others are founded. A general truth, an elementary proposition, a maxim, an axiom, a postulate, the collectivity of moral or ethical standards or judgments, a basic truth, law or assumption, a settled rule of action, a governing law of conduct, the collectivity of moral or ethical standards or judgments.
We have another reader. Someone who hasn't read. This is preparing leadership now. We're talking about leadership.
Legal values is legal principles. Jurisprudence, history, and institutional quality of law by Nicola Lacey, Virginia Law Review. Volume 101, 919. Cicero argued in his De Legibus that an understanding of law should not be derived from the formal source of legal rules, such as statute enacted by the popular assemblies or the edicts of magistrates. These rules are but one aspect of universal justice, which is to be found in the nature of man. Natural reason, which is fixed and developed in human mind and common to all men, whatever their cultural background, commands what ought to be done and forbids what should not be done. In fact, most legal values are humanity universal values, and therefore they have the same value in all legal systems, regardless of difference among them. Nevertheless, taking into account that legal values are some kinds of general, basic, and framework norms upon which a legal system is built, the legal values would be nothing more or less than what we have already presented as legal principles. In fact, legal values of a legal system can be identified also with the main characteristics of a legal system. As such, they outline the foundations of a legal system, and thus they are at the same time legal principles.
All right. You have another reader. Future leaders. Leaders of tomorrow.
Tracing the linkage between history and into jurisprudence. I'm sorry, I couldn't see that my video was down. All right. The core operation of law entails an invocation, interpretation of the past. In this vision, law is not so much a system of articulated general rules as a system of custom and convention generated by expression and continuing a particular cultural identity and a distinctive spirit or set of values. The historical nature of equity jurisprudence by Howard L. Olek, Fortham Law Review, Volume 20, Issue 1, Article 2, 1951. The nature of equity administratively is due primarily to its development historically in England and the United States. Its nature as an ideal juristic theory is much older and more universal. The two phases of equity have not developed pari passu. Nevertheless, hold on, let me get my video up here. Nevertheless,
Pari passu.
All right, pari passu. Nevertheless, the two phases should not be divorced from each other. They are two sides of the same coin. A study of one is barren without consideration at the same time of the other, and a study of either must begin with history. Note, pari passu is a Latin term that means equal.
Latin phrase.
I didn't say Latin phrase.
No.
I thought I said pari passu is a Latin phrase that means footing or ranking equally and without preference.
Excuse me. Hold on, y'all. Somebody mute your mics, everyone, please. Mute your mics. Mute your mics, please. Thank you.
Pari passu, I'll read that again. Note,
Yes.
pari passu is a Latin phrase that means equal footing or ranking equally and without preference. It's used in many legal arguments to describe parties with equal rights. For example, pari passu means that all parties to a financial contract or claim are equally or treated equally. Ancient history of equity. Equally pertinent is the fact that an appellate jurisdiction existed in the ancient days and that the final judge of appeals was the king. Here is the very original of the pattern which was to appear almost 4,000 years later in England. The English kings, and was to be acclaimed as a novel product of English culture. I'll do that one again. Here is the very original of the pattern, which was to reappear almost 4,000 years later in England and was to be acclaimed as a novel product of English culture. The English kings and their chancellors were who established the equity courts, chancery, which we know today seem to have followed what now appears to be almost inevitable pattern of legal development. The appeal to the king is a recurring characteristic of equity. The law and lore of the Assyro-Babylonian culture were introduced to the West through the Hebrews. Led by the venerable Abraham, the Hebrews came from or the Chaldeans, to what was then the crossword
of. Read it again. Led by venerable. Read it again.
Led by the venerable Abraham, the Hebrews came from of the Chaldeans to what was then the crossroads of the ancient world. Palestine, circa 2000 to 1800 BC. There, in intimate contact with the second great civilization of antiquity, Egypt, the Hebrews elaborated the laws of their former home into the monolithic body of law, now known as the Mosaic Code, destined to be the basis of much of the law of all the nations of the Western world. closely resembling.
Let's stop there. Let's analyze that now.
Okay.
So this article, and I wanted to have this read today, and this time I typed up 2 pages. As you see what Elkanah just read, that it says, he said, last part, basis of much of the law of all the nations of the Western world. So that you know that what the foundation is, the foundation that these England and France and Germany and Holland and Portugal, what they're standing on. They didn't develop anything.
Mm-hmm.
They've watered down, not developed. Not developed, extracted, distorted, watered down, and you'll see that as he continues to read, but not the word develop. Another example, I gave this to King today. What they call the letter A that you've been writing all your life. The letter A you've been writing all your life. Where did that come from? That you've been writing all your life. Let's invert it. Invert it, because that's the original, because that's inverted. It's a what? Bull's horn, bull's head and horns. Yeah. Bull's head. So what you've been writing all your life.
It's an inverted A.
Is a bull's head and horns. Don't y'all write it in the bull's head and horn? What's that? Oh, what you call the letter A? That's bull's head and horns. Well, how did that bull's head and horn, Abdullah? Because it's agricultural connection.
Y'all be making too much noise.
All right, so why? Mute your mic. Mute your mics, please. So the bull in an agrarian society, bulls are what? Very valuable. So it's for plowing. The etymology of the word peculiar means cattle. How did it come to mean that the etymology of the word peculiar means strange, particular? The etymology pecu, cattle. Cattle in an agrarian society, not in the hood. In the hood, cattle is burdensome in the hood, but not in the agrarian society. That's wealth. The word fee, F-E-E, and the word peculiar have the same etymology. The words peculiar and fee are in the same family. I gave the word fellow on Monday. Fellow is also in that same family. Peculiar, fee, and fellow. Fellow is a blending of 2 words. Fee and leg. To lay down your wealth. That's called blending. When you talk about word formation, that's a blending of 2 words. Just like the word fill up. Fill up is a blending. It's called blending. That's the word formation. In word formation, you have affixes, that's prefixes and suffixes. Affixes. You have blending. Blending. That's as in the word. You have blending and the word fill up. Philos and hippos. That's blending. Fill up. Fee, fellow, blending of 2 words. Pecu and leg, to lay down your wealth. So I just wanted to give that to you. So since that was audio because I had given that to King earlier. So that's So that's the letter A. Now, the point I'm making is make it clear is that they did not develop what you've been writing all your life. That's not a development. All right. How hard it is to what? It's just turn it, just, just all you did was flip it. All they did was flip it. How hard is that? Oh, that's great creativity. Oh, wow. The Europeans are so geniuses. Wow, they're so creative. Wow. Man, they took and they just, what I mean? All they did was it took great creativity, to just take the A and just flip that. Wow, it's so great and so wow, what contribution that they give. Man, the Europeans are the greatest of all times. They great contribution. Wow, they just flip the stuff and wow, they're so great. Man, let me give the Europeans a hand to being so great and contributing to civilization. Y'all know I'm being facetious. All right? So we can nail the point home. Just doing it to nail a point home. Continue.
All right, hold on. I gotta find my spot. Sorry. Closely resembling, right? Yeah, it's all the way at the top. I'm on my phone, so that's the reason why I'm squinting and looking down, missing words. Closely resembling the codes of Mesopotamian nations, the Mosaic Code far surpassed then in its scope and detail. Moral principles introduced by the Hebrews, distilled from their extraordinary religious genius, lent to their code and a strong feeling of morality, equity in its broad sense. In fact, the very term equity appears in the Old Testament to receive the instruction of wisdom, justice, and judgment and equity. While this may be due to its English rendition in the King James Bible, the concept in whatever terms is biblical. Once again, also the right to appeal to the king appears. The story of the judgment of Solomon is known to every schoolboy. It is interesting to speculate upon what our laws would be like today. The Hebrews.
It's supposed to be if. My bad.
Okay, all right. If the Hebrews had not preserved their progenitor.
Progenitor. Pro means fourth, and then genitor means source, as in Genesis. Genesis, all right. So means that. So progenitor means, all right. So had not preserved their progenitor code. All right, go ahead.
Okay. Had not preserved their progenitor codes from the destruction that befell Assyria and Babylon. The brutal harshness of the laws of the Medes and the Persians, the conquerors who overthrew Assyria-Babylonia, is proverbial. The very language of the ancient empires vanished almost 3,000 years ago. Not until the Middle Ages of the 18th century was a start made on deciphering the records of Assyria and Babylon. Later, with the addition of the New Testament, the Bible became the very basis of all Western civilization and law. The nature is too well known to need any description here. Suffice to say that equity is its very essence. Hebrew law, softened by Christianity and made orderly by Roman practicality, was to become the law of the Western world.
We have another read. King, you have anything you want to add or elucidate? King is not with us. All right. We have another reader.
Hi everyone. The legal system is a crucial framework that governs societies worldwide. It provides a structure for resolving conflicts, enforcing laws, and upholding justice. The legal system encompasses various components, including legislation, courts, law enforcement agencies, and legal professionals. It plays a vital role in maintaining order, protecting individual rights, and ensuring the functioning of a fair and equitable society. One of the fundamental aspects of any legal system is legislation. Laws are created to regulate and guide behavior within a society. Legislators, such as parliaments or congresses, are responsible for drafting, debating, and passing laws. Legislation ensures that societies have a clear set of rules to follow and provides a framework for addressing legal issues. Courts are integral to the legal system as they serve as the venues for resolving disputes and administrating justice.
Continue.
The 5 law systems in the world: common law legal system.
That's supposed to be legal systems. The 5 legal systems. My typo.
The 5 legal systems in the world: common law legal system, civil law legal system, religious legal system, mixed law legal system, customary law legal system. Note, the courts of a country do not constitute a legal system. Court is a component of a nation's legal system.
And I needed to put that there because the general public, that's Moors, conscious and unconscious Moors, and Europeans, will refer to court as the legal system. So when people hear the legal system, they court, the legal system, court. We have to change that narrative. We have to change that narrative. So because we need to, as we are, moving into the recovery of our lost Moorish sovereignty, self-determination, self-governance, all right, we need to understand that court is a component of a nation's legal system and not the legal system. There's 5 legal systems. So we know what the 5 legal systems are. Court is a component of a country's legal system. So I need to we need to pound that. And I know I'll take some time because you'll hear legal system 1,000 times or 10,000 times in the past 3 or 4 years, next 3 or 4 years. And, people associated with court, the court, right? That is an error.
Question.
King, you have a question? We have a question? Yes,
Question.
Go ahead.
Kara Eliale Bey here. Is the word ecclesiastical and religious legal system, is that interchangeable? I'm just looking back through my notes when we first started doing it. Okay.
Yes.
No, that's all I want to know.
King, I wanted to, if you had, we just finished up that article. Did you want to, and then I don't know how much you've heard of it when Elkanah was reading, and then you wanted to add to that?
So we looking at what Elkanah was reading a deeper context. So when we went back, right, it says it was talking about a deeper understanding, right? So what we have to understand when we're looking and comparing the law to understand its original essence, its intent. What was it intended to do? What was its purpose? What was the law supposed to do? It gives you a better, deeper understanding. He was giving you the parts of the historical context rooted in certain individual societies from the Mosaic and the Hebrews, how they contribute to understanding these philosophies and this theory based on observation and application, right? how they came about equity. So what is the purpose when you get a true understanding of the court and its system? This is how you will know if your government is for you or not. Without understanding these principles, you won't. For example, the main primary purpose of the court is to solve dispute and make both parties whole. Not to oppress, not to put people in impoverished conditions. That wasn't what the law was created for. It was to help dissolve disputes in a civil manner so people can live in peace and both have equity, can experience equity. But when you don't understand this and you're not rooted in the principles, you don't see the light. So most of us go to court, they have what they call a penal system. The statutory law, which they now really should be penal law, is based in penalization, penalizing people. Do that sound like a just system? Do that sound like a system for the people? I understand there is consequences, but people are getting pulled out of their car and everything for not wearing a seatbelt. For having a headlight out or a tail light out. People are getting choked for saying they're non-compliant, saying because they can't breathe. People are being policed. This is the European mindset. They took and corrupted the legal system and to make it an oppressive, corrupt system. They changed the essence of what our ancestors meant for law to be. And when you understand this, you can better shape your thought process. You can better understand once you understand these principles. Law is supposed to be equal on both sides. Why? That's what the person of equity. Equal. Okay. Me and you had a contract. I was supposed to have 10 apples. You were supposed to get 10 pears. I end up getting 5 pears. You got 10 apples. The court is going to make you give me my 5 pears due to the fact that I gave you 10 apples. Now we're equal. Dispute solved. Not to live in tyranny, in terror, not to be torn down. That's what never the purpose of law, based on what my brother read. Once you understand this, you get this in your head, understand these principles, you can better thrive at legal, understanding what we're doing here, how to properly litigate. Most of us is what they call misappropriation of law. Misappropriating the law. Because you don't know how to properly analyze your case. You don't know how to think proper. Because the school system don't teach you this. They keep you outside of this so that they can always have a tactical advantage. I yield, Abdul.
That's why I wanted you to. I know you're gonna have something to share. All right. We put that back up there, Terrence. It seems like we're gonna be going over, Terrence. You want to have to leave at 5 o'clock?
Yeah, we'll make sure.
Yeah, give it to her because I want to spend out those 3 things I sent to you. We want to spend a good hour on that section. That's the last section of the day. We want to spend a good hour on that last section. We'll be finishing up we'll be heading to that last section in about 15 minutes.
Okay, cool.
All right, yeah, we'll just be able to, because of King's great explanation, extensive explanation, we'll be able to these 2 points we made. All right, so we have a reader. We have another reader.
Legal principles. Legal.
Another reader.
I want to read, but my background kind of. I want to read.
We got more than 2 or 3 people on. We got.
Start
Yes, go ahead.
Out.
Go ahead. Jump right on in. We got about 20 people on this joint.
Legal principles play a crucial role in shaping and providing.
Did you read? This is Cara. Is that Cara?
Yeah, this Cara.
Did you read earlier?
Yeah, I read earlier.
All right, that's what I thought I heard you right. Can we have a person who has not read, please?
Legal principles.
All right, is that Mark?
Yes.
All right, go ahead, Mark.
Legal principles play a crucial role in shaping, providing a foundation for proper functioning of law. The legal principles serve as a cornerstone for the creation, interpretation, application, ensuring justice and fairness in judicial decision, as well as in running governments in general. Why is having knowledge of legal principles important? 1, legal principles are the pathway to interpreting legal issues. 2, the knowledge of legal principles is key to analyzing legal cases. 3, legal principles offer a standardized and consistent application of law. Legal principles are classified as procedural legal principles and substantive legal principles. Procedural legal principles. 1, due process. 2, natural justice. 3, the rule of law. Substantive legal principles. 1, equity before the law. 2, presumption of innocence. 3, proportionality. 4, legal certainty. Other legal principles rooted in the legal process. 1, applications of law. 2, source of law. 3, operation of law. 4, separation of power. 5, fact-finding. 6, substantive law. 7, rules of procedures. 8, rules of court. Court decision doctrines. The court decision doctrines can refer to several principles that ensure the consistency, finality, and respect of judicial decisions. Each of these doctrines plays a crucial role in maintaining the integrity, efficiency, and fairness of judicial systems by ensuring that the court's decisions are respected and followed in subsequent related proceedings. 1, stare decisis. 2, res judicate. 3, collateral estoppel. 4, law of the case. 5.
Hey, Mark, that's a typo on my part. Number 2, it's supposed to be an A, res judicata. I'd have to, because res judicata. It's so that E is supposed to be an A. Thank you, Terrence. Res judicata.
2, res judicata. 3, collateral estoppel. 4, law of the case. 5, judicial estoppel. 6, mandate rule. 7, precedent. Rule of law of primary legal principles. The 2004 report of the Secretary General of the United Nations, entitled The Rule of Law and Transitional Justice in Conflict and Post-Conflict Societies. The rule of law refers to a principle of governance in which all persons, institutions, and entities, public and private, including the state itself, are accountable to laws that are publicly promulgated, equally enforced and independently adjudicated, and which are consistent with the international human rights norms and standards. It requires as well measures to ensure adherence to the principles of supremacy of law, equality before the law, accountability to the law, fairness in the applications of the law, separation of powers, participation in decision-making, legal certainty, avoidance of arbitration, and procedural and legal transparency. The World Justice Project definition of rule of law is based on 4 universal principles: accountability, again, the World Justice Project definition of the rule of law is based on 4 universal principles. 1, accountability. 2, just laws. 3, open government. 4, accessible and impartial dispute resolutions. Core principles of the rule of law. 1, superiority of the law. 2, separations of powers. 3, known predicable. 3, known and predicable. 4, equal application. 5, just laws. 6, robust and accessible enforcement. 7, independent judiciary. 8, right to participate. Additional principles that might be added to the definition of rule of law. A, protection of persons and property. B, understandable by ordinary persons. C, resolving disputes without excessive cost and delay. D, independent legal profession. E, emerging international rule of law. Legal principles in running governments. Legal principles as the DNA of a legal system and guide to restoring the Moors to sovereignty, self-determination, self-governance, self-rule, and self-authority. The Moors are the carpenters and must be given the proper tools to rebuild governments, restoring the rule of law and good governance among the Moors. 1, legal principles, the building blocks of a legal system. 2, what is your political system? 3, legal principles, the building blocks of constitution. A, legal principles as the guiding tools to drafting a constitution.
Explain. So we gave you above, you given the 5 major legal systems in the world, which is different from a political system. So they're not to be interchangeable. A political system, you have legal system, once again, common law legal system, civil law legal system, religious law legal system, customary law legal system, and mixed law legal system. You have political system, republic, constitutional monarch, absolute monarch, totalitarian, and there's several others. Those are political systems. They are not legal systems. They are political systems. Okay. All right. So I wanted to explain the difference. So next, Sarah, I think we'll be ready for these. We go down. All right. So after we read this, we'll have another reader after we read this paragraph. Terms, we're gonna be ready for those 3. All right. We have another reader. This is the last section. We'll spend an hour on this section. We have another reader. Leaders of tomorrow. Leaders of the day.
All right, I don't want there to be no dead air here. So as
go ahead, brother. Yeah, we can't have dead air.
As more legal principles in handling legal cases. As Moors, we must understand that we are on the road to recovering our lost Moorish sovereignty. This journey requires us to know how the law operates and to learn how the application of these laws works by meeting specific elements. These actions are rooted in the principles of legal application of law. To reclaim our lost Moorish sovereignty, we must present a strong case by the finding of facts that support our position. We need to demonstrate that we are in a continuous state of protest, establish a permanent population, and define our territory according to ancient treaties that affirm our rightful claims. And that should be reread again just to stamp that. But we must stop going to court with understated or invalid paperwork. Instead, we need to rely on credible,
unsubstantiated. Read it again. Unsubstantiated.
We must stop going to court with unsubstantiated or invalid paperwork. Instead, we need to rely on credible, well-documented evidence that is aligned with legal standards. It is important to understand that the United States or the United Nations are not the deciding entities in our return to our Moorish sovereignty. By understanding these principles and acquiring the necessary knowledge, we can effectively work towards restoring ourselves to our original sovereign state through either the reversion to sovereignty or post-liminium.
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 Written by Keng El Bey.
Written by Keng El Bey. Okay.
Mm-hmm. All right. So, Brother King. All right. All right. So this is the section. We have those three that you wrote today. We'll put them on the screen. All right. So just give us an introduction to this.
Okay. Affidavit, a fact-finding tool. So a lot of us don't understand what a affidavit is in relationship to evidentiary standards of practice, utilizing the rule of evidence. Affidavits can become in a form of it's a written statement that's taken under oath in the penalty of perjury, but it still needs to be weighed. What do I mean? A few things have to happen. The author of that affidavit has to come and authenticate it. What does that mean? He has to come to court and verify that he wrote it. That is his thoughts on that paper. Then it can be cross-examined to determine the credibility of the information, to see if there was any perjurious testimony, some misidentifiable facts, some facts that in lieu did not give clear or vague, that didn't give clear understanding, that may have gave a vague statement, or something that was vague where no one can really truly understand what was going on, and to give clarity. When you don't understand how the findings of facts works, through a fact-finding tool using the affidavit, the misconception was an affidavit stands as truth, which even under the rules of evidence,
it cannot be rebutted. The affidavit stands as truth and cannot be rebutted. But that's the misconception. That's what I want to complete it. The affidavit stands as truth and cannot be rebutted. That's the misconception.
So a lot of us, right, put in the affidavit. They don't move the court. That doesn't do us anything. The court do not respect affidavits in that manner because it's a misappropriation. You using it to try to get the court to do something instead of filing a writ or a motion. You put in affidavits and then the court cross-examine. So it says investigative tools that is used in deciding how admissible and credible a testimony is.
All right, so we
Use
have,
use
ahead.
a support of a memorandum of law or application of law to support additional findings with exhibit. Support one's position or argument based in evidence gathered. Due process, alternative dispute resolution, and public inquiries on and commissions. Okay. Yeah. Get my phone and my charger is in the bag.
The first one, Terrence. All right, so we have, like I said, we'll spend an hour on this section. As Terrence brings the first one up. All right, is that the
No, you gotta scroll, you gotta see the top. That's, I don't think that's, is that, we gotta scroll
you
down.
have the top part, Terrence? What?
That's the top of number 1 that you said.
That's the top of number 1, King. Is there a heading?
Yeah, I have key components and relationships.
All right, yeah, that's what I sent to Amanda too. What's the heading, Amanda?
Key components and relationships.
All right, this is key components and relationships. All right.
Sorry.
Okay, let me see. I'm gonna have to go to the original, Abdullah. I'm gonna pull it. So
Well, that always missing, King, is the top part.
I'm trying to see.
Here it is right there, King. King, this is it.
Let me see.
This is what you have. This is what you sent me.
Okay. Key components and relationship. So we're gonna talk about status. I thought I had status in there. Okay. So in order to activate an application, I need y'all to understand.
You have status, number 4, King.
Okay. So when we're talking about status, that's the first thing, because a lot of us talk about status and y'all been taught status correction. Okay. In order to effectively be able to file a application in a certain place, right, with a certain person, which is a entity, right? Your status, you must have the proper status to do such act, or it's automatically is going to be void because you're not in the capacity in which align to be able to file such application. So let me give you an example. Let's say I live in Ohio and Kentucky was right over the bridge. Let's say I go to Kentucky to receive a grant that is for Kentucky individuals. When I go to Ohio and I say that I am from the state of Ohio, and to receive these funds, let's say they've given $1,000 to people who live in Kentucky. When I come to Kentucky, based on the fact that I'm a resident of Ohio, my status is that I'm an Ohio resident. And since I'm not a Kentucky resident, my application is automatically denied because that's a key element that need to be inquired to be able to submit the application. So when we talk about persons, the individual applying for something, their status may include qualification, eligibility, or other attributes relevant to the application. So understanding status, most of y'all are misappropriating the law. If I'm in China and I'm asking to receive, let's say, food stamps, they might have a food stamps system, but I'm on vacation and I am a U.S. citizen, I automatically am disqualified. I will not qualify for those benefits based on my status. So the application in which I put in would be null and void because I don't carry the status. I want y'all to understand status is the relationship between persons, places, and things. This is how to apply. So let's go on. Place the geographical and jurisdictional area where the application is made. This could include, this could affect eligibility or the specific requirement that's need to be met. Thing could represent a specific document, asset, or other items necessary for the application process. Status. This is the foundational criteria that determines whether a person given a certain place or thing can apply for an application. Status affects the possibility of applying. Application, a formal request submitted by a person to receive something, e.g., a service or benefit or permit. Elements, the specific criteria or facts that's needed to be satisfied for the application to be approved. If all elements are met, the application may be granted. If not, it will be denied. Fail to meet the elements. If the application failed to meet the necessary elements for the application, is denied. Diagram structure. Based on the breakdown, here's how you visualize it. Central node status represents the base criteria for qualification of a person, place, and thing that are essential for starting an application. Branches for status, persons, place, or thing, right? Person, attributes or qualification like age, citizenship. Place, geographical area, jurisdictional rule. Thing, acquired documents, assets, or etc. Link for status to application. Show that a person with a certain status in a particular place having specific thing can be submit a application. Application 9. No. Connected to the elements. Specific requirements such as documents, fees, or other qualifications. Branches from the application. Element met. Needs to what that say? Okay, it's small. Leads to grant. Elements not met. Leads to denied. Okay.
We want to do is slow this down, King.
Okay.
I know he's reading. So just give a
So when I get into the next part, I'm a break it down even. I'm gonna slow it down a little bit. Could we move forward, Terrence?
All right.
So
we had the diagram outline, King. The diagram outline.
Okay, so status, person, place, a thing, right? Application, elements. Elements met, elements not met, right? So I want you to think about this when we're talking about law and filing when we're dealing with court cases, right? And we're gonna make this simple because I'm gonna break it down. Okay, you have two applications. We in a tier legal system. There's one under the common law and we're under the civil law. So when you are charged with a crime, the state is charging you with a particular application, right? The second application under the common law is the case. Why I say it's the case? Because you're going to show, right, if there's a remedy. You're going to show the application now. We're talking about status. So in order for the application, they first got to determine your status. that they can charge you with this particular crime, which is the application. That's the main one criteria, because a lot of y'all get this wrong, right? Then it goes down to findings of facts. You have the application, which is going to be the statute and the case law. Then you're going to have the findings of facts. What is the findings of facts? It's going to be affidavits that is being used as supporting. And then you're going to have the memorandum of law, in which you're going to show the elements within the case that your elements align with the memorandum of the law to show that you are protected and get the same remedy that this case already showed, because you have the same elements that exist. And then you have the conclusion. The conclusion is how the law was supposed to be performed based on these elements, based on the application, right? So I want you to think about this. Once again, if I go to McDonald's and I put in an application for a job, McDonald's say, hey, 2 things we require, right? They say that you have to have a high school diploma, but I'm just making this up, and you have to have a car. You put in this application. Now, the elements is a car and a high school diploma. Now, when you go into the interview, you say, well, hey, I qualify. I bring you my high school diploma, and I inform you I have a car. I might bring in my car type. Meeting the elements of the application to get the remedy of a job. I want you to think about that. That's the same application process when we're dealing with law. When you put in an application to get relief, you're going to state the statute and the case law. That's the application. Then you're going to show how you're entitled by meeting the elements in the case. By looking at the substantive language in the statute, showing that you have met those criteria of the substantive language, that you got proof of the substantive language, right? Let me give you a prime example. It might say, in order to, under this Ohio Revised Code, any person is a minister who is stopped by a police officer and given a ticket can sue for $100 while he's in his ministerial capacity. Okay? That's the statute. Now, I have to try to find case law under that same statute to show how I'm able to sue, right? And there's somebody already sued, right? That's the common law aspect. The precedents, the judge made law, that's the second application, because it's a 2.
King, paint your face, solar face into the camera.
Okay.
All right. Go ahead.
So now what do I have to do? I have to meet those elements. So the statute language said I can sue if I'm operating in my ministerial capacity. If a police officer give me a ticket, I can sue for, let's say, $1,000. I'm just making this up. So What do I got to prove? What do I got to do? I got to show that I was in my ministerial capacity. That's the element. That's one of the elements. In order to have the right to sue, I got to show that I was operating as a minister that day. When at the time of the stop, when I might have been going somewhere else. So what do I need? I might need a letter from the church or the temple or the institution showing my work schedule, showing that I was on assignment that day. And at that time, I was scheduled to meet a family or another minister for ministerial service. I may have an affidavit from personnel of the temple or church showing that they knew and they were part of giving the assignment for me to go meet the family or other ministers or whatever, right? Because that's the element. I got to show that element. Then, right, I then use those affidavits and other exhibits, right? Then I might have some exhibits. I might use the traffic ticket as an exhibit, which is going to, I got a traffic ticket. Because that's in traffic court, the traffic ticket in traffic court. I'm suing now, I'm in civil court. So I'm going to use the traffic ticket as an exhibit, a part of this, along with other exhibits, right? With me maybe in my ministerial uniform, right? I might have on minister clothes, may not. Might have my business card, ministerial business card, my minister's license, right? Showing that I'm a minister, right? And that I operate through the church, right? So I'm gonna use the church affidavit, and then I'm gonna have my own affidavit in support of the lawsuit and the claim supporting the law, and the exhibits is going to further support the affidavit in the law because it's going to reference. These are all elements that's going to show my claim. And then I'm going to conclude that I have met the operation of law in which grant me some relief based on the findings and facts. And this is how I'm gonna break down my case. Is that making sense to everyone?
Yes.
So let's go.
Questions. Before we go on, King, do we have any questions? Are there any questions? Remember, the misconception is that affidavits stand alone, all right, and cannot be refuted. Now, you don't, affidavits stand alone. You know, that's been, and cannot be refuted. So we just cleared up, you know, so I brought it to King's attention so that we can clear up misconceptions. This is the Moorish Investigative Research Committee. And a lot of us been saddled with misconceptions. So we have to strengthen our understanding by ruling out misconceptions. Because what happens is the misconceptions will continue to creep. They'll continue to creep. And then we trying to move on and put you on committees, and you continue, the misconception continue to creep, you know. Terrence knows what I'm talking about. Terrence will give you all I'm around what I'm saying.
Hey, Terrence, could you blow that up a little bit bigger?
Yeah, this is coming straight from the email because of how it was sent to me. So
Yeah, how it's not a word, like
Okay,
it's not a Word document. I don't know how we'll do it. We'll make sure it's Word document next time, King. I know
Okay.
you did this while you were in the library. You did this today, so I just didn't have time to type this. I was still working on, because
Okay.
if I had, I would have typed
Outline.
this up. I just didn't have time.
So you have two types of motions. You have a motion for action and claim relief, and then you have a defense motion. So we're gonna break down the first motion, the motion for action and claim of relief. Introduction. Brief overview of what is a motion for action is. Definition. A request by a party, plaintiff, asking the court for a specific relief. Importance. Understanding the process is crucial for effective pursuing a claim. Understanding key components. Y'all need to understand this. A motion for action, an explanation, a formal request to the court to take a specific action in a case. Purpose, allow a plaintiff to pursue a claim for relief based on a specific application. So when you put in an application, you need to know the language, the substantive language, and that you met the elements, right? You don't necessarily have to support it with case law, but at least you need to know what you're requesting for. And see if you met the elements in your complaint. Did you meet the elements? In accordance to a statute, if it's a tort, right? So let's say it's a federal tort. So you come in under United States Code that show that the person has a right to sue if he's been injured in a federal tort action, in an action in which exuberate a tort in which he can prove himself injured, right? I'm just making something up. Now, the elements that you have to meet in the statute, it says that injured. You got to know what the word injury. What is the element of injury? You got to show that you was injured. Not appear to be injured, not might been injured, but injured. So we need to understand what injury is. Injury could mean a loss of something, loss of life, a loss of limb, a loss of property, right? Intellectual, non-intellectual property. It's a loss. You could have went to jail. That's a loss of time. That's a loss of time. Your time is your property. That's property. That's property rights. Time falls under property. Because everyone on this earth has time. Your time is valuable. So you need to make sure when you're pursuing an action that you met the elements. Okay. Claim for relief, definition and requirements. Definition, a request made to the court for a remedy or judgment. Rightness. The claim must be right, meaning it must be ready for judicial review and decision. Why did I put right in there? Because sometimes the state they do this to us all the time. I'm talking to a brother. His family was arrested. But during the arrest, they're still doing an investigation, collecting more evidence. But they made charges to arrest. But then they've been locked up for over 17 months and still haven't been to trial. The prosecutor prematurely made an arrest because in 90 days, you're supposed to go into trial within 90 days under speedy trial violation. And the state must show, or the prosecutor, which is the state acting on the state behalf, must show just cause why the delay. And the only time that it is credible for such delay is that you have to toll the process. Tolling where is you have submitted certain documents or motions that slowed down the process in which took it off its natural course, in which made the case more delayed. You might have filed a motion due for continuance due to the fact you might have been in a car accident, you might have had a leg, now that's tolling. You might have had a broken leg and you couldn't move, you in the hospital. That's tolling. Or your mom died and you was going through something, you was grieving, and the court said, okay, boom. Or you could have been in Ramadan where you had to fast and pray, and the court said, we're going to grant your religious, that is tolling the process. That's going to slow down speedy trial, right? I'm working with Michael. Michael said the judge told him, hey, I didn't see your motion. You filed a motion to dismiss a motion for discovery and some other motions he put in. That's not tolling. You have a right to be heard on those motions, especially when motions show that you're innocent and the prosecutor is still, with the evidence that he has, knows that you have enough supporting evidence to exonerate you, and he still continued to prosecute you. That's malicious. Now that can be determined as malicious prosecution because he has the evidence. Let's continue. Application and basis could be based on contracts, case law, statute, treaty, or other legal foundations. So this could be a convention. I just want to let y'all know, when we're dealing with international law, we're talking about international conventions, right? Those can be in there in a treaty violation, a couple with treaty violations that they had, that the acting party was under this convention, and they known or should have known that they shouldn't have been behaving in this capacity because they signed off on a treaty or under that convention where there are a willful participant and that they had knowledge. That's what they call known or should have known. Contract. You might be coming in. And another thing, when we're looking at mortgages and all of this stuff, they might be prematurely moving before they haven't met all the elements in the contract. They might be moving on a claim, right? And if you ain't read your contract, you ain't gonna know where they supposed to do certain things before they can sue. They might have to give a letter of intent to sue. And that might be in the contract. But if you don't read it, you ain't gonna know. So the court, and if you don't object, what? I don't have it. You have it. Come. Tell Riri to look at my red bag. So when you don't understand these things, you don't know how to properly object.
Hold on, King. Hold on, King. Terrence. Amanda.
I'm here. No,
Are
go
you
ahead.
gonna take?
Just keep
Is
going.
Amanda? You gonna give it to Amanda over, or?
Yeah, just keep going. I'll let
We're
you know.
going till 5:30. All right.
Okay, that's fine.
Go ahead, King.
So you got to understand this.
You're muted, King.
Stop. So you got to understand these concepts to be able to know how to do this. You got to understand these principles. I'm giving y'all the basics based on applications and studies of applications and remedy based on application. Application of law, status, being able to sue in a court. Okay. No. So let's go into burden of proof. So another thing, when we look at these applications, we must understand the plaintiff burden of proof. The plaintiff must show and prove the elements identified in the facts, must demonstrate how the law applies to a specific facts. We talking about operation of law, family.
Do we have any, and are there any questions at this time? Any questions at this time? Elkanah, you talking without, you have a question? You're muted. Elkanah. You're muted, Elkanah.
It looks like he's trying to get it, so.
All right. All right.
All right, I'm sorry. I'm trying. This
I know.
this technology, man. My students gonna get me together this year. Trust me. Yeah, not a question on what King just read, but the paragraph or the article that I read, I wanted us to see if we can go. I guess we don't have to go back to that, but I guess get some explanation on that the next time we meet, because there was some vital things in that. But I don't want to go backwards. I don't want to
go back right now. But he did mention King came back on and then did.
He did.
But we won't be able to do that. We'll do that later. I don't want to break the flow. That's
all right. So yeah,
no,
I don't have any questions right now.
No problem. Yeah, we won't be able to do that now because I had to break the flow.
All right.
So,
all right.
Cool.
I want you to see how the application, how this works. I want you to understand the thought process to go in and winning claims. People ask me, King, how you be so successful? How was you so successful at winning claims? I understood these principles and I put them into application. I put them into use. I understood the application of law, source of law, operation of law, evidentiary standards. These are principles surrounding fundamental rights, which is another principle. Due process, another principle. I started understanding that the United States is a two-tier legal system. It's operating in the capacity of a civil law system. At the same time, it's operating in a what? A common law system. Then I started to understand the constitutionality of every case. I noticed there wasn't such thing as criminal jurisdiction and civil jurisdiction. Now, I didn't say that's the same as criminal actions or criminal procedures and civil procedures. Those are different from civil and criminal jurisdictions. You got to understand the words do matter. So when looking at this and breaking this application down, and looking at the methodology for a claim of relief, I had to understand all of these different moving parts. So let's go down to methodology for proving a claim, findings of facts. Definition, the process of presenting facts to establish the basis of a claim. So if you lay out something, right, you lay down a claim. That's called the substantive language. The whole entire thing that you put together is composed of what they call substantive language. That's the language. The language that you use determine right? Because you wrote it. You must understand is you gonna meet the elements. If the state wrote it, then if you coming under an application that the legislator wrote, you got to know what that meant in that terminology under that application. And look at the basis of the elements. The elements is the principle associated with that claim. Did you meet those elements? Your facts must identify with those elements. So if the element says that, for example, they say that every blue car get a ticket if he drive after 10, and they gave you a ticket and your car was pink, right? Did you meet the elements or the language in the statute? No. And they gave you a ticket based on the construction of the language that they use, right? But your car, they said every blue car that drive after 10 o'clock or whatever. And you driving a pink car at 11, right? They say every blue car driving after 10 o'clock get a ticket, traffic ticket. But you driving a pink car and you driving at 11 o'clock. Did you deserve that ticket based on the construction of the language? The element, one of the element was blue car. Your car is pink. So their application in which they presented to the court should be denied. Because they didn't, the prosecutor presented a claim that didn't meet the elements. So he did not have no relief to be granted. You got something to say, Abdullah?
Yeah, you breaking it down elementary, brother. Elementary, my dear Watson. Elementary, my dear Watson.
So we must understand that. So road to convince court of validity of the plaintiff claim. You must show the court, sway the court. What do I mean by sway? When you in a civil case, they use the preponderance of evidence standard. That's an evidentiary standard. I'm gonna say this again. They use the preponderance of evidence standard. That is an evidentiary standard. What do that mean? They don't mean you have to sway the court a lot, just a little. That means you can win 51-49. You just got to sway the court by a small percentage, not a whole lot. It's just that your evidence and the way you broke yours down based on the sequence of events, based on the evidence and how you told the story made more sense than what they explained, because their evidence and their claim was choppy, broke up, inconsistent, wasn't fluid. It had a lot of holes. They didn't have all the evidence. They wasn't properly prepared. So when you get into court, we looking for fluidity. We looking at putting things in a proper context, proper timeline. You're looking for your stuff to show. It got to break down. And like I said, it got to have fluidity. It got to have comprehensive. Got to be comprehensible. It got to be in order. So that means you got to know the structure. I was showing in Mike's case the structure. His stuff was numbered. He had a number line. Why did he have a number line? So when I made reference to things, I told the judge what number line to go to that support the law, the memorandum all of that was numbered. So the judge didn't have to fumble through my paperwork to find anything. I told him the source. I gave him the application and the memorandum. It was numbered. And then I gave him the source to go to on the affidavit, which was numbered, the lines to look at to support the law. And then I gave him the corresponding exhibits. So he didn't have to fumble through my paperwork and read everything, trying to make, he didn't have to make sense of the case for me. I made it make sense for him. So it made his job easier to come to a conclusion. If you're not doing that, you can have a good paperwork, but if you're not doing that, then you may not be meeting what you need. You might have all the good stuff, but because you don't have it orderly where the judge can follow it, then you probably don't get the remedy just because you're unorderly. Because that's part of the rules of the court. You got exhibits, but they're not labeled exhibits. You got an affidavit, but it's not, don't have a number line. You got a memorandum that don't have a number line. So the judge can't cross-reference nothing. That's like having a book without a table of contents with page numbers. The person got to read, the person might want certain excerpts out the book, but in order to get through the book or get certain information, that means he has to read the entire book to get to the resolution that he was looking for. That ain't what we doing here. We break it all the way down, make it simple, understandable, and we make it simple for the court to understand. Okay, tools and evidence used in this process. Memorandum of law, written document explaining the legal reason for the claim. Affidavit, a sworn statement of facts made by a witness or party. Exhibits, physical or digital evidence presented to support the claim. Forensics and material evidence. Scientific and factual evidence supporting the claim. Somebody break into your car, cut themselves, leave blood, fingerprints. Find out it's your brother, right? Based on DNA evidence. It make a match. They take the blood samples and they make a match. Presenting the case, presentment to the court. How to organize and present evidence to show a clear, logical argument. That's what I'm talking about. I see this one is missed so far. I see so many people, Moors, they had their paperwork in, it ain't numbered, it ain't got none of this stuff. They don't have none of this. They don't have table of contents. They don't have none of this stuff. When you file a brief, you got to have a table of contents. If you file an motion, you got to have your motions and everything together, the memorandum of law, the affidavit's numbered, the exhibit's numbered, everything numbered so the court can follow. This is probably one of the most important things that a lot of us miss. Importance of clarity, thoroughness in the documents and argument. Once you understand this structure, it makes it so simple. You're able to then present the case and make it easy for the judge to rule in your favor. When you lay it out this way, the judge can follow the case and break it down and say, you know what, this is a no-brainer. Operation of law. Explanation of how the law applies to the facts of the case. Demonstrate the legal basis for the claim and requested relief. Right? Conclusion of law. Objections. Aim to sway the court in favor of the plaintiff request for relief. Final thoughts. Importance of preparation and understanding the legal procedures. Encourage the assurance of all evidence and arguments are well prepared and presented. Do y'all have any questions? Because I got to get into the second part.
Can you go to the top and just slowly stroll down? Let's go to the top. The very top, and just slowly stroke down. So let's tell you what, let's read tell you what, go back up. All right, outline, motion for action and claim for relief. Number 1, introduction. Number 2, understanding key components, just to recap. Motions for actions. Number 3, claim for relief, definition and requirements, application basis, plaintiff's burden of proof. Number 4, methodology for proving a claim, findings of facts, tools and evidence used in the process, memorandum of law, affidavit, exhibit, forensics, and material evidence. Number 5, presenting the case, presentment to the court, operation of law. 6, conclusion, objectives, and final thoughts. And we have here number 7, Q&A session. I just want that for those who will be viewing this in the recording. All right, so that was a good. We'll probably want to do. I probably want to do that with the others. So, any questions? Any Q&A? So we have 15 minutes here. 15 minutes. We have some more at the bottom. King, is this part of it?
Yeah, this is the second one. Motion to the for defense.
This is the second one. So we can tell you what. Let's slowly. This is the second one. All right, go up. Here's an outline for creating a motion for defense and response. So this is just a review. Here's an outline for creating motion for defense and response to a motion for action, focusing on challenging the plaintiff's claim for relief and the evidence presented. This outline will guide you through the essential components and strategies to effectively defend against the claim. Outline, motion for defense. 1, introduction. Number 2.
Okay.
Number 2, understanding the basis for defense. We have challenged to the ripeness of the claim, disputing the legal basis of the application, burden of proof lies with the plaintiff. Number 3, defense strategies, finding of facts and legal challenges, challenging the application of law. Number 4, rebutting plaintiff's evidence, memorandum of rebutting plaintiff evidence, memorandum of law, affidavits, exhibits and material evidence, forensics and scientific evidence. 5, asserting affirmative defenses, legal defenses, equitable defenses. 6, motion for dismissal or summary judgment, grounds for dismissal, request for summary judgment. 7, conclusion, summary of defense arguments. Request to the court, Q&A session. Right, that was number 2. All right, so we just want to do a recap. All right, so
let me just break this down real slow for y'all.
Yes.
Because it's rooted in the same principle. It's just on the opposite side. So the plaintiff make a claim. You have to rebut the claim. First of all, you need to understand the language in the statute to determine, for example, if they make an approved mature claim. Their claim may not even be right. For example, they might say that a person who is 17 and under cannot be charged for a crime of kissing a 18-year-old in public distancing, right? So the person may be 16. The statute might say, in order to charge you can't be 17 or under for kissing in public, saying there's public indecency, right? So the claim ain't right. Your son might be charged with a claim for public indecency. That means that it wasn't right. Why it wasn't right? Because he wasn't of the age necessary to be charged. Just giving you an example. So that's an affirmative defense based on what? Rightness of the action. He wasn't 18. I just made that up. So that's one thing. So when you're looking at the same theme that we're looking at, you have to meet, when you lay out a claim or a defense, you have to meet the elements. What do that mean? When you state something, right, look at the application, you're going to do the same thing when you assert an action. But is this in the form of the defense? And then you're going to state what? Okay, here's the application under the statute, which is the application. The case law, which is another application, right? And you're going to show that in the substantive language of the application, right, that the criteria for them to even charge your son publicly for kissing, for indecent, for public indecency, is that the requirements that you got to be of 18 years age. So that's an element. Your son met the element because he ain't 18. Then you might find a case law that says El Bey versus the state of Ohio, where they charged someone else. And the Supreme Court looked at the elements and said, well, you charged El Bey in this matter, who was only 16, in which the statute may even encroach upon his right because they might have been in a car. So now you got to look at the circumstances. Where was the kids kissing? Was they in the building? Was they outside the building? Was they in a car? Let's say your kids was in a car like these kids. That's the circumstances surrounding the case. They was in a car. They went inside a public place. And the officer gave them a ticket. And the Supreme Court broke it down, said based on the substantive language in Gray versus the state of Ohio, El Bey versus the state of Ohio, that the court, that the elements did not align, and that the defendant in error met these such elements, that they was kissing on a public road in the car, outside of a public place, and that he wasn't of 18 years of age to even be charged. So you take those two applications, and then what do? Your son put in an affidavit stating where they was kissing, what happened, what time it happened, and that the officer gave him a ticket. Then he may use the ticket itself as an exhibit. Everything is already numbered. The exhibit is labeled Exhibit A, B, C, or 1, 2, 3, 4, 5, 6, 7, 8. And he presented it in such a manner where the judge can look at the law, look at the statute, look at the memorandum, his argument, his legal argument, as he said, in accordance and pursuant to El Bey versus state of Ohio, that he meets the claim of relief based on the following elements: that he's not 18 years of age, he was outside a public place, and These are the elements required. See affidavit of support. And then the affidavit is going to state the facts that he's less than 18 years of age, and they was in the car, where they might then use the exhibits of a picture of a car, the car they were in, the license plate number that correspond with the ticket, the traffic ticket itself, and maybe his birth certificate, right? Showing that his age, that he's not 18 years of age, meeting the criteria and the elements of his case. And that he should meet the same equal protection, have the same fate as the other person who already won, that the court got to protect him the same way that they protected this other person based on this case. Once you understand how to break this down systematically, it becomes simple. You don't have to think about it. I can look at a case just by going through it, reading over it, and I can tell you if you did a good job or a bad job. I don't have to guess.
I don't have to guess.
I don't have to, because I'm rooted in understanding the principles. I know what to look for. I'm a surgeon. I'm a technician. Let me ask y'all this. When y'all go to a surgeon, do you want a surgeon who has no experience? He's doing a heart surgery. He has no experience. Would you want him cutting on you, trying to repair your heart? Or would you want a technician, a surgeon who has performed 300 surgeries, who is technically proficient in operating and getting to the heart and closing up and sewing you back up? The difference between the two, they both doctors. One just have knowledge and the other one doesn't have the knowledge. This is what me and Abdullah is talking about. Without the knowledge, you're not a technician. You're not a surgeon. You are not going to be surgically able to tear apart a claim and put it back together. You're going to be missing because you're not rooted in principles of law. You're not going to know how to meet the elements. You're not going to know how to legally present your case. You're not going to have a number. You're going to be all over the place because a lot of y'all think y'all got it, but I can tell you, if you ain't got your stuff numbered, you ain't doing it like that you're not proficient, because the court demands that you do it like that. Why? Why do they want you to do it like that? Because they have a high volume of cases. They don't want to spend all this time on your case. So what do? They throw your stuff in trash 57, in file 57, the trash. They ain't gonna help you find a remedy. They're not gonna help you put your case together and make it make sense. If you're not breaking it down elementary for them to follow, to see, to show the remedy, they're not gonna do it for you. And you can have all the evidence, you can be totally right, you can be totally innocent, it don't even matter. Because they say next, because they're in the line of business of making money, privatizing business. Prisons are privatized businesses. Any questions? Did I make sense to everyone tonight?
This is like a follow-up on Mike's case. That was, the actual case. And this is great because you actually made that, gave us a review. You actually came up with you made up some cases and showed us the process. This is very good. This is very good. And as we prepare over the next 3 months to 3 months from now, we'll be breaking down onto subcommittees to subcommittees. So we'll see who will be heading subcommittees, all right?
I got one thing to say before we get out of here. I want y'all to understand the road to recovery to sovereignty. You must understand these applications. The application to recovery to sovereignty is not forcing yourself in the building, unprepared, trying to argue a claim, saying that you have a government when you have not met those elements. Every application of law has specific elements that you must meet in order to claim such application and to say that you met such application. You cannot misuse this process to a point where you think you got it all and you think because you with a group, y'all formed a group, and y'all agree that y'all government. That's not how it works. You must have the knowledge. And if you don't understand the application of reversion to law sovereignty, and you don't know what's requirement, and then you go in there talking about you counsel the jurisdiction, and you haven't met some of the elements to pursue such claim by doing certain things, then you can be leading your people and yourself into a burning building. You must follow and adhere to this. I'm telling you, you must understand this. I hope y'all understand this. You will lead your people into a burning building if you don't know these principles. The stuff that we teaching you, I didn't get it for free. I had to take years of my life to understand what I was doing. Years. I'm giving it to you. I'm giving it.
Much appreciated, nobles.
Abdullah, doctorate's degree. Not a PhD. He has a what do you
Masters.
have, Abdullah?
Masters.
A master's degree.
Yeah.
A graduate's degree.
Yeah.
Years of college education, etymology, studies, 30 years. He's giving you to this. Please pick this up and learn this information so that we can then get back to the reversion and recovery of law sovereignty by understanding these applications and meeting these elements. The UN don't give us that. We don't need their approval. The United States, we don't need their approval. We must meet the elements. We must understand the principles associated with the legal system. We must understand what kind of government we're going to run. We must understand what kind of legal system we're going to use. Or we're going to be a laughingstock of the world. Me and Abdullah said we're going to bring credibility to this movement, and we're going to give you these principles. I give.
All right, this will be available if not today, tomorrow. Terrence will post it on the Telegram page. I will post it on my Abdullah Bey Facebook page. We'll send it out, and y'all post it as well. You can post. You are able to post this, share it out to thousands of people. Let's get it out to hundreds of thousands. Let's get this out to hundreds of thousands. The other videos on the Moroccan Post Media YouTube page. Go to the Moroccan Post Media YouTube page for the other 4 classes as well as other classes. You can post any of the classes. You can share it to your cousins, brothers, nieces, nephews, mothers, fathers, uncles, friends, co-workers, etc. Post on your Facebook page. Share those on your Facebook friends. All right. So we got to push this. All right. This is for it to share. You can share it. You can share this out. Let other people know they can share it and post it on their various social media platforms. All right. Once again, the Moroccan Post Media YouTube page. On Monday, I have brother Abendele Amin, you said Il Amin, Brother Bendele Il Amin will be my guest on
Yobachi Elamin.
What is it?
Bandale Yobachi Elamin.
Yobachi Elamin will be my guest on Monday, Moorish Monday with Abdullah Il Talib Mosi Bey on Magnet Crystal Pyramid YouTube page at 7 p.m. Eastern Standard Time, 6 p.m. Central Time, 4 p.m. Pacific Time. All right, that's this coming Monday. That's in 2 days. All right, so I'll see y'all on Monday, 7 p.m. Eastern Standard Time. Once this video is made available, I will get it out. I will send it out to y'all. It will be on the for the Love of Moors Telegram page, for the Moroccan Post School of Government and International Law Telegram page, for the Abdullah Bey's Facebook page. It'll be on. I'll send out to some of y'all who actually post. I always send out to DuPont, Kenneth, and all that. Vasirs and all. Y'all will all get it. Amanda, Prince, y'all will all get it. Israel, you'll get it because you posted as well. So y'all will get it. All right. Brother Mark, I'll send out to you as well. Elkanah, you'll get it as well as others. I'll send out to about 500 people, and I will post it, and y'all do the same.
Noble, I say.
My man. All right. Peace, everyone. Thank you again. Assalamu alaikum. Beta Makem.
Alhamdulillah. In Lakesh.